Item 2, Misuse of Drugs Amendment Bill, second reading.
Minister for Home Affairs. Leader.
Mr. Speaker, may I seek your consent and the general assent of members present to move that on the proceedings and the item under discussion be exempted from the provisions of Standing Order number 48.8 to remove the time limit in respect of MOS Faishal's speech.
I give my consent as the Leader of the House of the general assent of honourable members present to so move. Leader, please proceed.
Mr. Speaker, I beg to move that the proceedings and the item under discussion be exempted from the provisions of Standing Order number 48.8 in respect of MOS Faishal's speech.
Question is as moved by the Leader of the House. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. MOS Faisal.
Mr. Speaker, on behalf of the Minister for Home Affairs, I beg to move that the Misuse of Drugs Amendment Bill be now read a second time. Sir, the bill is linked to the next bill on the order paper, the Constitution of the Republic of Singapore Amendment Bill. May I propose that the debates on both bills take place together?
Please proceed.
Sir, we will still have the formal second reading of the Constitution of the Republic of Singapore Amendment Bill to comply with the procedural requirements. The Constitution of the Republic of Singapore Amendment Bill also contains two other sets of amendments not related to the Misuse of Drugs Amendment Bill. One set led by the Ministry of Law and the other by the Ministry of Finance. I will explain MHA, MinLaw and MOF's amendments in my opening speech. I will address questions pertaining to the amendments led by MHA and MinLaw. Second Minister for Finance, Ms. Indrani Raja, will address questions pertaining to MOF's amendments. Sir, the global drug situation is worsening. Illicit drug supply, drug abuse, and the potency of some narcotic drugs are reaching unprecedented levels. The 2022 World Drug Report published by the UN Office of Drugs and Crime, or UNODC for short, found that young people abuse drugs more than adults. The UNODC also found that in many countries, the levels of drug abuse among the youths have reached record levels. The number of deaths worldwide associated with drug abuse increased by 17.5% between 2009 and 2019, reaching about 500,000 deaths in 2019. Drugs cause great harm to individuals, families, and the society. Many countries around the world have given up on this fight because drug trafficking and use have become so prevalent and they cannot stem the tide. For these countries, the only practical approach is to reduce the harm. In Singapore, our situation is different. Our tough laws have kept the drug situation here relatively under control. We must continue to keep drugs at bay to prevent the harms from overwhelming us. To this end, we continually review and refine our laws and policies to keep pace with the evolving drug landscape and local trends. Mr. Speaker, in this Misuse of Drugs Amendment Bill, we will introduce two key amendments to address emerging trends in the local drug situation. we will be introducing a legislative framework to deal with psychoactive substances. We will also be introducing a tiered punishment framework for the drug possession offense. Over the last few years, we have seen the rise of a new trend in the drug landscape. New psychoactive substances, or NPS short, are synthetically produced substances which mimic the effects of traditional controlled drugs such as cocaine, heroin, and cannabis. Around the world, NPS are proliferating at an unprecedented rate, from just 166 NPS detected in 2009 to 1,150 in 2022, a seven-fold increase in slightly over a decade. Locally, the number of NPS abusers arrested increased from an average of 3 abusers per year between 2014 to 2017 to an average of 235 per year from 2018 to 2022. NPS are harmful, and their abuse has been linked to adverse physical and psychological reactions and also overdose deaths. These substances are no less harmful than controlled drugs and are similar in effect. NPS are often clandestinely manufactured. The UNODC has reported that NPS users are frequently hospitalized with severe intoxication. In Singapore, there have been at least 4 NPS-related deaths since 2016. Because the psychoactive effect that NPS causes is similar to that of a controlled drug, its abuse will also lead to acts of crime and violence. Members will remember some recent cases within Singapore where drug abusers acted violently, such as the LSD abuser who killed his mother and grandmother in 2019, or the meth abuser who attacked 2 other diners with a knife in a restaurant in 2022 because his food was not ready. We have not seen similar incidents arising from NPS abuse yet. We should nip the NPS problem in the bud. Currently, we manage NPS in the following way. Once we detect an NPS, we will list its molecular structure in the 5th schedule of the MDA. Section 58A of the MDA allows for such listing up to a year. During this 1-year period, the Central Narcotics Bureau, or CNB, can seize the substance to prevent its proliferation. CNB will use this time to conduct industry consultations to determine if the substance has any legitimate uses. During this 1 year, CNB cannot take any prosecutorial action against a person trafficking in the substance. If there are no legitimate uses, its molecular structure will subsequently be listed in the 1st schedule of the MDA as a controlled drug. Only when it is listed in the 1st schedule can a person who is found trafficking, manufacturing, importing, exporting, or possessing such NPS be prosecuted. The limitation of the current approach is that we will always be playing catch-up with the syndicates. The ease in modifying the molecular structure of NPS to create new variants means that traffickers can easily overcome our laws by switching to new, unlisted NPS. In fact, drug suppliers are known to tailor the molecular structure of NPS according to what is not yet controlled through legislation. We need to put in place a more proactive approach. We studied the drug legislation in the UK and Australia and adopted parts of them to develop our own unique framework to tackle NPS. We are proposing a new legislative framework to deal with the NPS threat based on their capacity to produce a psychoactive effect rather than their molecular structure. This allows CNB to take enforcement action against potentially dangerous and potent NPS and not have to wait until their molecular structure has been identified and listed in the MDA. The new framework criminalizes the manufacture, import, and export, traffic, possession, and consumption of all psychoactive substances. The first limb of the definition of a psychoactive substance, as inserted by Clause 2, is a substance or product which is capable of producing a psychoactive effect if consumed. NPS in this bill will be referred to generally as psychoactive substances. Psychoactive effect is defined to mean the stimulation or depression, whether directly or indirectly, of the individual's central nervous system, affecting the individual's mental functioning or emotional state. The first limb of the definition of psychoactive substance is broad and may cover substances that are already regulated under other legislation or those with legitimate uses. Therefore, we have created a new fifth schedule of excluded substances, which will not be considered as nor regulated as psychoactive substances, as reflected under the second limb of the definition of psychoactive substance. The new fifth schedule will list substances that have the capacity to have psychoactive effect on an individual but with legitimate uses, or those which are already regulated under other legislation such as caffeine, alcohol, food, tobacco, and any medicinal product. I explained the method of temporary listing earlier. The existing fifth schedule used to temporarily list MPS will be repealed since there is no longer a need for temporary listing. To be clear, there is no change to the existing regime for controlled drugs. All controlled drugs listed in the first schedule will continue to be regulated in the same way as before. That is why controlled drugs are also listed as excluded substances in the new fifth schedule. The punishment framework for these new offenses relating to psychoactive substances will take reference from that for Class C controlled drugs, but generally with fines in place of caning. The proposed definition of psychoactive substances covers a broad scope of substances with different levels of psychoactivity, and because they are novel, their potential harms may not be as well documented as those of controlled drugs. This approach therefore balances the need for deterrence against the uncertainty over the universe of psychoactive substances with varying levels of potential harms. Once the molecular structure of a specific psychoactive substance is identified and industry consultation has been conducted to determine the substance has no legitimate use, we will list the substance in the first schedule as a controlled drug. This substance will at that point no longer be treated as a psychoactive substance as defined in the MDA. In 2019, we introduced offenses to criminalize acts of contamination that contribute to the spread of drug abuse and child endangerment through exposure to drugs. Clause 7 introduces the same contamination and child endangerment offenses for psychoactive substances. The punishment will be the same as the offenses where Class C controlled drugs are involved, including caning. We propose for caning to be retained for contamination offenses to better protect vulnerable members of society. Repeat offenders with antecedent of the same nature, whether for psychoactive substances or controlled drugs, will be liable for higher punishments. For example, if an offender has an antecedent for trafficking in a controlled drug and is now convicted of trafficking in a psychoactive substance, he will be considered a repeat offender and will be subject to enhanced punishment. I will now speak about issues relating to the element of knowledge for offenses concerning psychoactive substances. The MDA currently contains statutory presumptions relating to controlled drugs which, when invoked, shift the burden of proof to the accused person to prove otherwise on a balance of probabilities. For example, that he did not have knowledge of the nature of the drug found in his possession. Clauses 10 to 14 extend these presumptions to psychoactive substances. Clause 15 introduces a new section 22A. I beg your pardon. Clause 15 introduces a new section 22A, which provides that for the purpose of proving that the substance in question is a psychoactive substance, it is sufficient for the prosecution to prove that the substance has the capacity to have a psychoactive effect on an individual if consumed. An accused person who claims that the psychoactive substance is an excluded substance bears the burden of proving this claim on a balance of probabilities. For the new offenses criminalizing the manufacture, import, and export, traffic, and possession of psychoactive substances introduced in Clause 7, it is a defense for the accused person to prove on a balance of probabilities that he dealt with the substance for a legitimate purpose other than human consumption. The burden for proving this defense likewise falls on the accused person. For example, if a person is arrested with a substance found to be capable of producing a psychoactive effect and claims that he intended to use the substance as a cleaning chemical, he would need to produce evidence to show that he intended to use the psychoactive substance in his possession for cleaning and not for human consumption. This is fair, as there is a wide range of substances that have the capacity to have a psychoactive effect on a person if consumed, with an equally wide range of uses for these substances. The person dealing in the substance would know best what the substance is and the intended use of the substance, if it truly has a legitimate purpose other than for abuse. In addition, Clause 15 inserts a new Section 22B, which provides that knowledge that a substance is a psychoactive substance is established for the purposes of offenses concerning psychoactive substances if the person knew the substance had the capacity to have a psychoactive effect on an individual when consumed and did not know or have reason to believe that the substance is an excluded substance. For avoidance of doubt, Section 22B provides that the person need not have known the exact name or molecular structure of the substance in order for his knowledge of the psychoactive substance to be established. Next, we are amending Section 16. Scientific certificates issued under Section 16 may be used as proof of the matters contained within relating to controlled drugs unless the contrary is proved. Clause 9 extends the effect of Section 16 to apply to certificates relating to psychoactive substances. Operationally, the Home Team Science and Technology Agency, HTX, will be conducting the relevant tests on seized substances during investigations into an offense relating to psychoactive substances. As such, Clause 9 also amends Section 16 to allow HTX analysts to sign certificates issued under Section 16. Sir, we will also amend the MDA to extend the existing powers of law enforcement officers in respect of controlled drugs to apply equally to psychoactive substances. Clauses 16, 17, and 18 extend officers' powers of search, seizure, and arrest to apply in relation to psychoactive substances. Clause 19 amends Section 27 to allow for the forfeiture of any psychoactive substance seized under the MDA. Clauses 21, 22, and 23 amend Sections 31, 31A, 31B to extend officers' powers to collect urine specimens, hair specimens, and oral fluids in cases of suspected psychoactive substance abuse. Where appropriate, abusers of psychoactive substances may be subjected to treatment and rehabilitation, similar to abusers of controlled drugs. Clause 2B expands the definition of drug addict to include a person who is addicted to a psychoactive substance. This allows the director of CMB to subject him to supervision or treatment and rehabilitation, which includes committal to the Drug Rehabilitation Center, DRC. We will also amend Article 9, Clause 6b of the Constitution. Article 9, Clause 6b ensures that laws relating to the misuse of drugs, such as MDA, that authorize the arrest and detention of any person for the purpose of treatment and rehabilitation are valid under the Constitution. We propose to include psychoactive substances into this clause to ensure the constitutional validity of the Director of CMB's proposed powers to commit persons who have abused psychoactive substances to detention for treatment and rehabilitation. The bill will make consequential and related amendments to 9 other acts. These are technical amendments needed to align these acts with the new legislative framework for NPS, such as to update the enforcement powers in those acts to also cover psychoactive substances. I will now move on to explain the second key amendment in the Misuse of Drugs Amendment Bill. In recent years, CMB has seen the modus operandi of syndicate shift towards dealing in larger quantities of drugs per transaction. For example, in September 2022, there was a large seizure of 13 kilograms of drugs, which had included 8 kilograms of cannabis, as well as a seizure of 18 kilograms of heroin in May 2022. These were exceptionally large seizures, amounting to millions of dollars in street value. The current punishment for possession offenses are not differentiated by the type of drugs involved and are not tiered based on the quantity of the drugs. It therefore does not sufficiently account for the greater harms that could be caused by a person in possession of larger quantities of drugs. Persons who are willing to risk being in possession of such large quantities of drugs contribute significantly to fueling the local drug market and feeding local drug demand. We need a more deterrent sentencing regime. MHA therefore proposes to increase punishments, which will include caning for the possession of selected controlled drugs above certain weight thresholds. Clause 34 amends the second schedule to increase the penalties for the offense of the unauthorized possession of certain quantities of selected drugs. The drugs for which this amendment will apply are cannabis, cannabis mixture, cannabis resin, cocaine, diamorphine, methamphetamine, morphine, and opium. We scope the new framework to these 8 drugs based on our assessment that they have the highest potential to cause serious harms in our local context. Currently, the maximum punishment for possession of any controlled drug, regardless of weight, is 10 years imprisonment or a fine of up to $20,000 or both. The bill proposes to tier the penalties according to the quantity of the controlled drug. In the proposed enhanced punishment framework, for the lowest tier, the punishment is a maximum of 10 years imprisonment or a fine of up to $20,000 or both. For the middle tier, the minimum mandatory sentence will be 10 years imprisonment and 5 strokes of the cane, while the maximum is set at 20 years imprisonment and 10 strokes of the cane. For the highest tier, the minimum mandatory sentence will be 20 years imprisonment and 10 strokes of the cane, while the maximum is set at 30 years imprisonment and 15 strokes of the cane. I would like to emphasize that this new punishment framework does not affect the policy change that was announced in Parliament in 2019 when we last amended the MDA. Since 2019, we have been diverting pure drug abusers to DRC for treatment and rehabilitation instead of prosecuting them. The Minister for Home Affairs had explained then that pure abusers referred to drug abusers who did not commit any other offenses besides drug consumption, but who may face other less serious related drug offenses such as possession of drug-taking utensils or small quantities of drugs. However, drug abusers found with large amount of drugs in their possession would not be considered pure drug abusers and would not be considered for diversion to the DRC. Thus, there is thus no change to the approach we take for pure drug abusers. For persons in possession of large quantities of drugs, CMB will continue to conduct thorough investigation to determine if the drugs were meant for trafficking, their own consumption, or otherwise. Depending on the facts of the case, CMB will make its recommendations to AGC on the appropriate charges, for example, whether for trafficking or simply possession. The amendments to the punishment framework do not affect this investigation and prosecution process and will only affect the eventual sentence faced by a person who is convicted of a possession offense. The bill will also make some technical amendments. The current definition of article liable to seizure in Section 2 includes any money, thing, controlled equipment, controlled material, or anything that contains evidence of an offense. This may not apply intuitively to things that constitute and do not contain evidence of an offense, like jewelry. Clause 2 amends the definition to include the word constitute. This will align with the language used for a similar provision relating to seizure of evidence in the Criminal Procedure Code 2010 CPC. Next, Section 11 of the MDA makes it an offense for an owner, tenant, occupier, or person in charge of any place or premises to permit that place to be used for drug consumption or trafficking. Clause 3 amends Section 11 to clarify that such a person only commits an offense if the drug consumption mentioned in Section 11, subsection A, is in contravention of Section 8, subsection B, for being unauthorized, which constitutes the drug consumption offense. Next, Section 11C criminalizes introducing a person whom he knows is a drug trafficker to another person. Clause 5 amends Section 11C to clarify a person, A, only commits a Section 11C offense if A knows or has reason to believe that B intends to procure a controlled drug and the possession of the controlled drug by B or any person B passes it to would not be authorized under the Act. Likewise, person A would only be liable for the Section 11C offense if he knows or has reason to believe that B intends, without any authorization under the Act, to smoke, administer, or consume the controlled drug. To illustrate, if someone offers to introduce his friend to a person whom he knows is a drug trafficker, he will only be liable for a Section 11C offense if he knows or believes that this friend intends to buy drugs from this trafficker for unauthorized consumption. We will also make amendments to Section 24, 25, and 26 to clarify that an officer may make seizure based on reasonable suspicion. Clauses 16, 17, and 18 make these amendments respectively. The current sections 24, 25, and 26, if read literally, seem to suggest that CMB can only seize any drug, substance, or article which is confirmed to be a controlled drug or substance, article liable to seizure, drug specified in the 5th schedule, or substance containing any drug specified in that schedule. In practice, it is not possible for CMB to only seize such drugs, substances, or articles after confirmation of their nature, since this can only be confirmed after the drug, substance, or article has undergone scientific analysis after seizure. Likewise, Section 24 suggests that officers can only seize or detain any vehicle which has been confirmed to be used in the commission of or in connection with an offence under the MDA. However, it is not always conclusive at first instant if a vehicle is linked to the offence, and further investigations after seizure are often needed. So these are operational matters that we want to make it consistent and practical. These amendments align the position in the MDA with the powers of investigation provided for under the CPC that are conferred on CMB officers when investigating drug offences, which enables seizure based on suspicion. Another set of amendments pertains to the provisions concerning drug abusers charged under the Singapore Armed Forces Act 1972 or the SAF Act. These amendments aim to clarify the policy intent for provision in the MDA concerning enhanced punishments and supervision for drug abusers convicted under the SAF Act and improve consistency between both regimes. Currently, SAF servicemen caught for drug consumption may be charged under Section 26 of the SAF Act or Section 34 of the SAF Act. Section 34 of the SAF Act may also be used to charge SAF servicemen for drug possession. Clause 25 amends Section 33 of the MDA to clarify that only previous convictions for drug consumption under Section 34 of the SAF Act and not for drug possession will count towards enhanced punishment for drug consumption under the MDA. Similarly, Clause 26 clarifies that only antecedents for drug consumption under Section 34 of the SAF Act will count towards long-term imprisonment under Section 33A of the MDA for the repeat consumption of specified drugs. Separately, Section 58, subsection 1Q, currently allows the Minister for Home Affairs to make regulations in respect of the supervision and aftercare persons convicted of an offence under Section 34 of the SAF Act. However, there is no similar provision for the Minister to make regulations in respect of persons convicted of an offence under Section 26 of the SAF Act. Clause 30 amends Section 58, subsection 1Q, to include those convicted under Section 26 of the SAF Act for drug consumption. Since there is a separate rehabilitation regime implemented by MINDEF for drug abusers convicted under Section 26 of the SAF Act, such offenders would generally not be placed under CMB's supervision. Nonetheless, this amendment will enable making of regulations to provide CMB with the discretion to do so on a case-by-case basis if both CMB and MINDEF assess that the individual would benefit from undergoing CMB supervision regime in addition to MINDEF's. Section 58, subsection 1Q is further amended to make clear that ministers' powers to make regulation providing for the supervision and aftercare of persons convicted under Section 34 of the SAF Act relate only to those convicted under the section for drug consumption and not for drug possession. We will also make amendments to broaden the scope of the recall provision under Section 31, subsection 1A of the MDA. Currently, Section 31, subsection 1A allows the Director of CMB to recall any former drug abuser to report for urine tests throughout the person's life to ensure that the person is no longer a drug addict. Clause 21 amends the definition of relevant person and relevant time in Section 31 to include persons convicted under Section 26 of the SAF Act for the consumption of a controlled drug or psychoactive substance. We will also amend Section 31 so that a person who has been convicted under Section 34 of the SAF Act for an offence involving consumption of a controlled drug or psychoactive substance can be subjected to the recall provision even if he had not previously undergone CMB's supervision. In short, with these amendments, the Director of CMB will be able to recall and subject any person who has been convicted for drug consumption under the SAF Act to a urine test. Mr. Speaker, please allow me to speak in Malay. Tuan Speaker, usulan pindaan bagi Akta Penyalahgunaan Dada atau MDA adalah satu langkah yang akan membantu kita mendahului lanskap dadah yang berubah. Terdapat dua kunci utama pindaan ini. Pertama, kita akan mengubah pendekatan terhadap pengawalan bahan psikoaktif supaya kita dapat bertindak dengan lebih cepat untuk menanganinya. Kedua, kita akan meningkatkan hukuman bagi pemilikan jumlah dadah terkawal terpilih yang besar. Izinkan saya bercakap pertama sekali tentang bahan psikoaktif baru atau NPS. NPS merupakan cabaran kepada agensi penguatkuasa undang-undang di seluruh dunia. Kerana sindiket dadah berupaya mengubah struktur molekul NPS dengan cepat untuk menghasilkan varian baru agar dapat mengelak daripada undang-undang kita. Buat masa ini, kita mengendalikan NPS dengan cara-cara yang berikut. Apabila kita mengesan NPS, kita akan menyenaraikan struktur molekulnya dalam jadual kelima MDA. MDA membolehkan penyenaraian sedemikian selama setahun. Dalam tempoh 1 tahun tersebut, Biro Narkotik Pusat CMB dapat merampas bahan untuk menghalang penyebarannya. CMB akan menggunakan masa ini untuk menjalankan konsultasi industri untuk menentukan sama ada bahan tersebut mempunyai kegunaan yang sah. Dalam tempoh setahun ini, CMB tidak boleh mengambil tindakan pendakwaan terhadap sesiapa yang mengedar bahan tersebut. Jika tidak terdapat sebarang kegunaan yang sah, struktur molekul bahan ini akan disenaraikan dalam jadual pertama MDA sebagai dadah terkawal. Hanya bila tersenarai dalam jadual pertama, sesiapa yang didapati mengedar, menghasilkan, mengimport, mengeksport atau memiliki bahan NPS tersebut boleh didakwa. Kegagalan pendekatan yang ada buat masa ini adalah kita sentiasa berkejar-kejaran dengan sindiket. Kemudahan dalam mengubah suai struktur molekul NPS untuk menghasilkan varian baru membolehkan pengedar mengatasi undang-undang kita dengan mudah dengan cara bertukar kepada NPS yang tidak tersenarai. Sesungguhnya pembekal dadah diketahui menyesuaikan struktur molekul NPS berdasarkan apa yang belum dikawal melalui perundangan. Justru kami mengusulkan rangka perundangan yang baru untuk menangani ancaman NPS berdasarkan kapasitinya untuk menimbulkan kesan psikoaktif dan bukan berdasarkan struktur molekulnya. Ini akan membolehkan CMB untuk mengambil tindakan undang-undang terhadap NPS yang berpotensi bahaya dan serius dan tidak perlu menunggu sehingga struktur molekulnya dikenalpasti dan disenaraikan dalam MDA. Kunci kedua pindaan adalah hukuman yang ditekadkan dan hukuman berperingkat bagi pemilikan jumlah besar dadah yang telah dikenalpasti. Rangka hukuman yang baru akan dikenakan kepada pemilikan morfin, heroin tulen, candu, kokain, ganja, resin ganja, campuran ganja dan metafetamin. Jenis-jenis dadah ini dinilai paling berbahaya dan memudaratkan di konteks Singapura. Dengan perubahan dalam perundangan kita, kita akan dapat mengukuhkan usaha kita dalam membentas dadah supaya masyarakat kita bebas daripada dadah. Back in English. In addition to the amendment related to treatment and rehabilitation for abusers of psychoactive substances, there are 2 other amendments to the Constitution made through the Constitution of the Republic of Singapore Amendment Bill. Technical amendments are made to clauses 4 and 6B of Article 46, replacing the word leave with permission. This is consistent with the same amendment made in other acts by the courts, Civil and Criminal Justice Reform Act 2021. There is no change to the meaning of the provision. Secondly, an amendment is proposed to introduce a legal mechanism to reduce the balance of the contingencies fund. DPM Lawrence Wong had, during the budget statement in February, said that the government will introduce a mechanism to reduce the balance of the contingencies funds. The objective is to maintain discipline in how the government manages its finances. Currently, there is a combined balance of $16 billion in the contingencies funds. In May 2020, at the height of the COVID-19 pandemic, MOF raised the contingencies funds balance from $3 billion to $16 billion to enable the government to meet urgent and unforeseen spending needs arising from the fast-evolving pandemic. This was done by appropriating monies from the consolidated fund through the second supplementary supply financial year 2020 bill. However, there is no legal mechanism today to effect a reduction of the balances to ensure fiscal discipline as we return to normalcy. Clause 4 of the bill amends Article 148C to permit the finance minister to reduce the balance of a contingencies fund if he is satisfied after proper inquiry that the sum to be withdrawn from the fund is in excess of what is likely necessary to meet an urgent and unforeseen need for expenditure. The minister is also required to present to Parliament a report of every reduction as soon as practicable after it is made. This will keep members informed of the balance of the contingencies funds. The transfer of sums from a contingencies fund to the consolidated or development fund does not provide the government with additional budget for spending. The government will need to run a balanced budget over its term. Any expenditure from the consolidated fund or development fund must be met by revenues raised and included in a supply bill that is presented to Parliament for approval. Such spending remains subject to the Reserves Protection Framework. As we return to normalcy following the COVID-19 pandemic, it is timely and prudent to reduce the contingencies fund balance. The amendments proposed in this bill will provide the mechanism for us to do so and ensures greater fiscal discipline while preserving the nimbleness to deal with urgent and unforeseen needs. After the bill is passed, MOF intends to reduce the contingencies funds balance from $16 billion to $6 billion and will submit a report to Parliament when that transfer has been made. Mr. Speaker, I beg to move.